So we will start now. Just before we start, I would like to let you know that the session is being recorded, so that you know. And yes, so it is my pleasure to introduce you to today's lecturer, Professor Thomas Giegerich. He's one of the directors of the Europa-Institut. He holds the chair of European Union Law, Public International Law, and Public Law at the Faculty of Law at the Saarland University. Since 2017, he also holds the Jean Monnet Chair of European Integration, Anti-Discrimination, Human Rights, and Diversity. And today, the lecture will be about an international and European human rights law perspective on gender equality and human rights. The floor is for you, Professor Giegerich.
Thank you very much, Mr. Belotaya, for your kind introduction, and welcome to all of you to this lecture session. I will make a presentation giving you some basic information on how international and European Union law protect the rights of women. I will occasionally ask questions to the audience, and I would love to have volunteers trying to answer these questions. And I would also ask you to interrupt me and ask your questions if there's anything you don't understand or you don't agree with. As the session is recorded, if you say anything, it will be recorded too, but I hope that doesn't really distract you from actively participating in the session. You can also use the chat room if you like. Mr. Belotaya will keep it under control, and questions you send to the chat room will be forwarded to me. Right, then this is a brief outline of what I will try to speak about and discuss with you. We'll start with the global level. The UN Charter, the Universal Declaration of Human Rights, general human rights treaties, and I use one example only, the International Covenant on Civil and Political Rights. Then, of course, the special treaty protecting women, CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. Then we turn to the European level, start with the Council of Europe, the European Convention on Human Rights, and other conventions, including the most important women-specific convention, the Istanbul Convention against Violence Against Women. And we'll end up with European Union law, primary law, as well as secondary law. Let's see how far we get. And here is the UN Charter of 1945. It may surprise you, but the UN Charter in 1945 initiated what one calls the human rights revolution, making human rights a subject of international law, and at the same time introducing women's rights. In the preamble already, you see, we, the peoples of the United Nations, determined, among others, to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, and then immediately in the equal rights of men and women. Have resolved to combine our efforts to accomplish these aims. That's just the preamble, but it gives you a feeling that equality, including equality between men and women, is of particular importance for the United Nations. There are substantive provisions that support this. Article 1 details the purposes of the United Nations, and one of the purposes, under number 3, is to achieve international cooperation in promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinctions as to, among others, sex. Equal rights, equal fundamental rights for men and women. To achieve international cooperation in promoting and encouraging respect in this regard is one of the purposes of the United Nations. You should also read Article 55, letter C, and 56 of the UN Charter that define the specific commitments of the organization and the member states to pursue the UN purposes, including purpose number 3, the one on the top of the slide. Now, what international obligations derive from this charter? We do have a pronouncement of the International Court of Justice in this regard, not concerning discrimination of women, but concerning racial discrimination. The court, in its advisory opinion on Namibia in 1971, said that the UN Charter prohibits racial discrimination, and I suggest that in a similar vein, it also prohibits discrimination of women. The Charter as such, which is something like the functional equivalent of a world constitution. So the World Constitution prohibits discrimination of women. And 193 states in the world are members of the United Nations and are bound by this World Constitution as an international treaty. The first universal human rights catalogue is the Universal Declaration of Human Rights of 1948. And it also deals not only with human rights in general, but also with specific rights of women, non-discrimination of women, and also specific substantive rights of women. I start with the prohibition of discrimination in Article 2. That says that everyone is entitled to all the rights and freedoms set forth in this declaration, without distinction of any kind, such as sex. No discrimination based on sex with regard to any of the rights and freedoms set forth in the declaration. Article 7 adds a general equal rights provision. All are equal before the law and are entitled without any discrimination to the equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. And that means, of course, that all are entitled to protection against discrimination based on sex, on gender. Article 16 concerns marriage, and it includes a specific provision guaranteeing equal rights. They, that means men and women, are entitled to equal rights as to marriage, during marriage, and at its dissolution. Equal rights with regard to marriage across the board. And it's very strict. They, men and women, are entitled to such equal rights. No conditions attached. I'll return to that in a minute. Article 23, paragraph 2, guarantees to everyone without any discrimination the right to equal pay for equal work. And that concerns women in particular, because it's a particular problem that women are paid less for equal work. So that was already guaranteed in the Universal Declaration of 1948. equal pay for equal work. And Article 25 concerns motherhood. Motherhood is entitled to special care and assistance, right? My question to you, what do you think is the legal quality of these pronouncements of equal rights for men and women in the Universal Declaration? Does anyone know? What's the legal status of this declaration? Yes, Ms. Nikolic, please.
Well, the declaration is considered a part of the international custom law, in a sense. So it is basically obligatory.
Mm-hmm.
But it was not in the beginning, so it was just a simple declaration without any such effect.
Yes, and what is the formal character of that declaration? Could you explain that?
Well, I think because all the countries of the UN have agreed to it.
Yes, and who is the author of that Universal Declaration?
The UN should be the author.
Yes, but a specific organ of the UN.
Oh, yeah, I don't know, actually. I might have known, but I forgot.
You will remember in a minute. Yes, Ms. Keskin.
I believe it's General Assembly.
The General Assembly of the United Nations, that is the organ in which all the member states are represented. And so, Ms. Nikolic, you were correct to say that all the member states agreed to that, more or less. It comes from the General Assembly as the representative organ of the entire membership of the United Nations. And if you look in the UN Charter, you'll find under Article 13, paragraph 1, that the General Assembly can do no more than make recommendations. So the Universal Declaration is a General Assembly resolution of 1948, and its formal character is that of a recommendation. The question now is, and Ms. Nikolic already gave us a possible answer, whether the Universal Declaration has somehow developed into a document that is legally binding. It's not just a political pronouncement, a recommendation anymore. It has developed into something better, into something that is legally binding. And Ms. Nikolic already suggested one argument you can make to show that the Universal Declaration has become binding under international law. And that is to consider it, nowadays at least, as a declaration of customary international law, of that unwritten customary international law that is reflected in the Universal Declaration. That is one possibility to show that the declaration has become binding. Not everyone would agree to that, by the way. Most people would agree that the most important guarantees of the Universal Declaration, not perhaps every detail, but the basic guarantees of the Declaration have become binding as customary international law. And the question is, are equal rights of men and women so important that they are among the fundamental guarantees of the Declaration and have already become binding under customary international law? I would agree on that, but I don't know whether there is a worldwide consensus on that. There's another possibility to argue for the legally binding character of the Universal Declaration. So customary international law is one possibility. There is another possibility. Could you think of another possibility, perhaps. To show, to demonstrate that the declaration has become legally binding under international law. Any idea? Do you know that the sources of international law, customary international law is one of the sources of international law, and another very important source of international law is what?
Treaties, international
treaties. Yes, treaties. Does the Universal Declaration have anything to do with treaty law, perhaps?
Yes, indeed, because some of the articles found their place in the subsequent treaties, such as
yes, indeed, and we'll come to that in a minute. But apart from these subsequent treaties, does it have any connection with a previous treaty, perhaps? It's so easy. What treaty is the basis for that declaration? The World Constitution, the UN Charter. That is a treaty. That is a treaty. And there are some people who say that the Universal Declaration is an authoritative interpretation of treaty commitments that derive from the UN Charter with regard to human rights. You know, the UN Charter as such does not include a comprehensive human rights catalogue. It just prohibits discrimination, as I showed you. But it shows that there are some human rights commitments within the UN system, but they are not defined any further. And so you use the Universal Declaration to help us find the human rights commitment for the member states deriving from the UN Charter as an authoritative interpretation of the UN Charter. That's another possibility to show that the declaration is binding under international law. And as I showed you, that equal rights for men and women are specifically spelled out in the UN Charter, it's rather easy to show that those parts of the declaration that deal with equal rights for men and women are an authoritative interpretation of those clauses of the UN Charter. Right. Any further?
Yes, I would like to ask something. Isn't that though very contested, the sort of interpretation that the UN Charter is basically giving the declaration sort of binding power?
Yes, of course. It's as contested as the argument that the Universal Declaration...
Because I know that most states would say then that it also applies to the recommendations that the General Assembly gives, so they don't really want to go to that route.
Yeah, but you could say the Universal Declaration is of a very special character. And
well, of course.
When you say with regard to the declaration, wouldn't automatically apply to each and every General Assembly resolution.
I would also like to ask, I forgot, but didn't the International Court basically state that the Universal Declaration is a part of custom law, in a sense, for racial discrimination?
No, they said that racial discrimination is prohibited by the Charter.
Okay, that makes more sense.
And this is why I said if the court uses the same clause that prohibits racial discrimination and discrimination based on sex in the same sentence, the court would also, in all likelihood, consider that the Charter as such prohibits discrimination based on sex. Hasn't done so far. Hasn't been asked to do so. I just draw a conclusion from what the court said with regard to racial discrimination, because I think there is no way to distinguish between the prohibition of racial discrimination and the prohibition of discrimination based on sex. But there is no specific pronouncement in this regard, not yet. Right.
Thank you.
You're welcome. Now the question arises, how does one implement women's rights under the Charter and the Universal Declaration? Are they just theoretical, or is there a possibility to enforce them, to implement them? Well, we do have the political processes of the UN Human Rights Council. The UN Human Rights Council is a subsidiary organ of the UN General Assembly. And that council has established a number of political processes that also help implement the commitments under the Universal Declaration. There is the Universal Periodic Review Mechanism. That is a mechanism which all 193 member states of the United Nations must go through periodically. No exceptions. Each and every member state is subject to that Universal Periodic Review with regard to the human rights situation. And that review mechanism is also based on the Charter and the Universal Declaration, and in addition to that, the human rights treaties which the specific state has ratified. But apart from that, and in addition to that, it's always also considered human rights obligations arising under the Charter and the Universal Declaration of Human Rights. And that Universal Periodic Review mechanism is aimed at improving the human rights situation on the ground, fully integrating a gender perspective. That's important to keep in mind. So the gender perspective is part and parcel of that Universal Periodic Review mechanism. There are also special procedures besides that Universal Periodic Review mechanism. We currently have 11 country mandates and 44 thematic mandates, including discrimination against women and girls, violence against women, trafficking in persons, especially women and children, violence and discrimination based on sexual orientation and gender identity. So there are several thematic mandates dealing specifically with women's rights. And then, of course, there is a complaint procedure. It is aimed at addressing consistent patterns of gross and reliably attested violations of all human rights and fundamental freedoms occurring in any part of the world under any circumstances. It's a secret procedure, a confidential procedure, but it can be used if someone can show a consistent pattern of gross and reliably attested human rights violations, and that would also cover a consistent pattern of discrimination of women or violence against women or trafficking in women and so on and so forth. I'm not aware of any pending complaint procedure with regard to women's rights, but the possibility exists, and I wanted to mention it. All right. Any question or remarks from your side on the implementation processes? Then we can continue and speak about what Ms. Straukovich already mentioned, that the promises made by the Universal Declaration have meanwhile been transformed into specific treaty commitments. Also, the promises made with regard to gender equality and women's rights. These commitments were transformed into binding treaty commitments in the International Covenant on Civil and Political Rights of 1966, in the International Covenant on Economic, Social and Cultural Rights, also of 1966. They are twins, more or less, these two covenants, and first and foremost in the very specific Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, of 1979. For reasons of time, I cannot go into the second covenant on economic, social, and cultural rights. I will stick to the ICCPR and then continue with CEDAW. The ICCPR takes up the prohibition of discrimination, which we find already in the Universal Declaration, that each state party has to respect and ensure to all individuals the rights recognized in the present covenant without distinction of any kind, such as sex. No gender discrimination with regard to any of the rights covered by the International Covenant on Civil and Political Rights. And even if in times of public emergency a state derogates from its treaty obligations, such measures that the state takes to combat that emergency must not involve discrimination on the ground of sex. So no public emergency, no war, no nothing can justify derogation from the prohibition of discrimination based on sex. With regard to marriage rights, you'll see that Article 23 of the Covenant is a bit less strict than the companion provision in the Universal Declaration. Yes, the right of men and women of marriageable age to marry and to found a family shall be recognized. No marriage shall be entered into without the free and full consent of the intending spouses. Now, how about equal rights within marriage? Well, paragraph 4, states parties shall take appropriate steps to ensure equality of rights and responsibilities of spouses as to marriage, during marriage, and at its dissolution. What's the difference with the companion provision in the Universal Declaration? States shall take appropriate steps. The Declaration said men and women shall have equal rights as to marriage, during marriage, and at its dissolution. What's the difference? Possible difference, at least. Yes, Ms. Nikolic?
Yes, the covenant gives states the obligation to act. So it's an activity that the states needs to do to ensure such equal rights.
Yes.
While in the declaration, it's more of a passive right in a sense that it should just give equality, but no activity from the state is mandatory in a sense.
So you give me the impression that you believe the covenant is stricter than the declaration.
Well, I believe that the declaration is more general in a sense than the actual covenant. So
yes, Ms. Slavkovic, what do you think?
Yeah, I couldn't agree. In this particular matter, Universal Declaration has a more strict language, while the Covenant makes this as a goal that states should achieve a sort of like the language used in the economic Covenant.
That reminds of that. So the states should take steps, small steps, gradually, appropriate steps, and so on and so forth. I still would like to hear one specific term to distinguish the two provisions. A term that hints at the possibility of implementing human rights. States are obliged to do this and that. People have the right to this and that. What's the difference? Possibly. Well, the difference between self-executing provisions and non-self-executing provisions. Yeah, Ms. Hitashvili?
Yes, I would say positive and negative obligation from the state to implement special provisions. So I would say positive, it's when the state's supposed to be more active regarding in order to secure rights, the special rights and obligation for the citizens. And positive, it's more sorry, negative was negative is more when they have a little bit passive positions. I mean, state have a passive position in order to protect rights.
Well, that's a question of positive obligation of states to protect women, for instance, against interferences in their rights from their male partners. That would be a positive obligation. But I don't think that this difference between positive and negative is involved in our comparison here. I think it's more the difference between self-executing provisions, provisions on which individuals can base claims on the basis of which they can file suits in courts without state legislative acts transforming these obligations into positive law. And Article 23, paragraph 4 sounds like a non-self-executing provision, meaning that it is not self-enforceable. No one can immediately and directly rely on 23 paragraph 4 to file a court case against someone else. While the formulation of the companion provision in the Universal Declaration is formulated as a self-executing provision from which individual rights can be immediately and directly derived. So that is, I think, the difference if you compare the two provisions. All right. As another provision in the covenant concerning children, no distinction as to sex with regard to children and the protection of children. So no less protection for girls than for boys. And with regard to Article 25, that's the right of political participation. Every citizen shall have that right without any distinction, any of the distinctions mentioned in Article 2. In other words, also without any distinctions based on sex. So women do have the same rights of political participation as men. The right to vote, the right to take part in the conduct of public affairs, and the right of access to public service. And another provision on non-discrimination, Article 26, equality before the law and protection against any form of discrimination, also on the basis of sex. And that is a protective duty that imposes definitely positive obligations on states to protect women against discrimination based on sex. How does one implement the obligations, the treaty obligations? No question that they are binding under international law, the treaty obligations deriving from the Covenant. Well, we do have a treaty body, the Human Rights Committee, that is a body of independent experts that supervises the implementation of the Covenant. We do have regular state reports. Each and every state party has to report on the fulfillment of its treaty obligations, and the Human Rights Committee can then transmit observations articulating its concerns and making recommendations, including with regard to the rights of women, of course. We do have an interstate communication procedure, but only if both parties have recognized the competence of the Human Rights Committee by separate declarations, that is set forth in Article 41 of the Covenant. And that interstate communication procedure is aimed at a friendly solution. The Human Rights Committee in that procedure has no power to determine or express views on whether one of the parties has violated its obligations under the Covenant. And we also have an individual communications procedure under the optional protocol to the International Covenant. The optional protocol is a separate international treaty, so that the communication, the individual communication procedure, is only possible against states that have not only ratified the Covenant, but additionally ratified the optional protocol. Now, only with regard to parties to the optional protocol, and after the exhaustion of domestic remedies. So if there is a woman which considers itself discriminated on the basis of sex, it can and has to exhaust the domestic remedies in this particular state, and thereafter it can send an individual communication to the Human Rights Committee complaining about sexual discrimination by that state. And the Human Rights Committee can give its views finding a violation, so that in the view of the Human Rights Committee, a violation had taken place. There was a discrimination of that woman on account of her sex. But the views of the Human Rights Committee in the individual communication procedure are not legally binding. They are not court decisions. They are just views. They do have an important role, of course, but they are not as such legally binding. Any questions? Okay, then let's turn to the one particularly important convention, CEDAW, the Convention on the Elimination of Discrimination Against Women. It was only in 1979 that the promise of the UN Charter of Equal Rights for Men and Women became the subject of a woman-specific human rights treaty, CEDAW. CEDAW goes far beyond the symmetrical prohibition of discrimination based on sex and specifically focuses on discrimination against women as an evil that must be effectively eradicated. The preamble of CEDAW explains the reason why we need it, the raison d'être. It says that despite the previous instruments, despite the covenants, extensive discrimination against women continues to exist. What do you think 42 years later? Does extensive discrimination against women still continue to exist 42 years after the signature of CEDAW? Of course, still exists. How about CEDAW's motivation? Why is it important to fight discrimination against women? Well, discrimination against women hampers the growth of the prosperity of society and the family and makes more difficult the full development of the potentialities of women in the service of their countries and of humanity. We as humans simply cannot afford to discriminate the better half of the world's population. We need women, and so we must eradicate women to enable them to fully contribute to the development of their countries and of humanity as a whole. It's a selfish motive. We, as men, have a vested interest in ending discrimination of women. A second aspect of the motivation of CEDAW, the full and complete development of a country, the welfare of the world, and the cause of peace require the maximum participation of women on equal terms with men in all fields. We need them. We cannot afford discrimination. We cannot afford to lock them away, to let them just care for children and just do the cooking and the cleaning at home. And we men then wage war. That's crazy. And what's the specific target that CEDAW has in mind? It's a change in the traditional role of men as well as the role of women in society and in the family that is needed to achieve full equality between men and women. We must change that traditional role of the superior men and the inferior women in society and in the family. Only then can we accomplish the goal of equal rights of men and women. And that's important to keep in mind, and that makes it so difficult because that traditional role has sort of hardened during centuries, if not millennia. We have to change it, but it's really hard work. And this is why extensive discrimination against women still continues to exist, even after 42 years of existence of CEDAW. Any questions from your side? Well, CEDAW is one of the most widely accepted human rights treaties. It has 189 states parties, including Afghanistan, but not Iran, Somalia, Sudan, and the fourth pariah state, the United States. On the other hand, CEDAW is also subject to many general and indeterminate reservations, such as reservations attempting to subordinate treaty obligations to domestic or religious laws and traditions. One example is the reservation by Saudi Arabia, which subjects the treaty commitments to the compatibility with the Sharia. Many of these reservations are incompatible with the CEDAW's object and purpose, and thus impermissible under Article 28, paragraph 2 of CEDAW. States apparently felt politically compelled to join CEDAW, even though they do not really share its main goal. Other states have objected to those far-reaching reservations. It's a question of general international law, of treaty law, how to deal with impermissible reservations to treaties. I will not go into that because it's a bit tricky. The solution suggested by the International Law Commission in 2011 in its guide to practice on reservations to treaties is that a treaty ratification which is subject to an impermissible reservation is binding, and the reservation is detachable and void, so that the state is fully bound by the treaty without being able to rely on the impermissible reservation. But the International Law Commission would permit the state to choose on whether to stay a party to the treaty without the benefit of its impermissible reservation, or whether it would denounce the treaty and rather prefer to stay out of the system if it cannot invoke its reservation any further. But that's a solution suggested by the ILC, and it's uncertain whether that is also the solution which is based on customary international law. But that is nothing specific to the rights of women. I won't go into any further detail in this regard unless you have questions on that. But you see how contentious female and women's rights still are on the world level. All states are eager to join, but most only with tongue-in-cheek. What is discrimination against women? How does CEDAW define it? Well, the term discrimination against women shall mean any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms, in the political, economic, social, cultural, civil, or any other field across the board. That definition is more or less a copy of the definition of racial discrimination in the International Convention against on the elimination of all forms of racial discrimination, which preceded the CEDAW. Core state obligations under CEDAW are set forth in Articles 2 to 6. They are more or less the general part of CEDAW. Most importantly, according to Article 2, states parties have to prohibit discrimination, eradicate discrimination by public authorities and institutions, ensure the practical realization of the principle of equality of men and women, ensure effective protection of women against discrimination, and, quote, take all appropriate measures to eliminate discrimination against women by any person, organization, or enterprise, meaning, and that I added in square brackets, private persons, organization, or enterprise. States must eliminate discrimination by employers, by organizations, by private persons, and so on and so forth. It reaches far into private law relationships. Article 4 deals with the permissibility of affirmative action in favor of women to accelerate de facto equality. That affirmative action shall in no way entail as a consequence the maintenance of unequal or separate standards. So nothing like apartheid of men and women, which we do find in some state systems, unfortunately. And affirmative action, you want to protect women, is not a justification to uphold and maintain unequal or separate standards for all times. Measures to promote de facto equality of women shall be discontinued when the objectives of equality of opportunity and treatment have been achieved. Another important provision is Article 5 that deals with social and cultural patterns, prejudices, and stereotypes. They are the essential reasons why we still have discrimination of women. States parties shall take all appropriate measures to modify social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes, or on stereotyped roles for men and women, such as men are the breadwinners, women take care of children, that's their role. No, states must take measures to modify that kind of stereotypical behavior and thinking. They must also ensure that family education includes a proper understanding of maternity as a social function and the recognition of the common responsibility of men and women in the upbringing and development of their children, it being understood that the interest of the children is the primordial consideration in all cases. I will just give you a very brief overview of the special parts of CEDAW. Articles 7 to 9 set forth specific obligations concerning equal rights and non-discrimination in political and public life. Articles 10 to 16 prescribe action to be taken against discrimination in various sectors such as education, employment, healthcare, and family relations. According to Article 23, the Convention enshrines only minimum standards of equality, leaving the states parties free to enact provisions more conducive to the achievement of equality between men and women. And Article 24, CEDAW obliges state parties to undertake all necessary measures at the national level aimed at achieving the full realization of CEDAW rights. With regard to the implementation of CEDAW commitments, we also have a treaty body. It's called the Committee on the Elimination of Discrimination Against Women, also abbreviated CEDAW. We do have regular state reports, just as we have under the International Covenant on Civil and Political Rights. CEDAW, the committee, can transmit observations articulating its concerns and making recommendations. We do not have an interstate communication procedure, but an arbitration under Article 29. We do have an individual communication procedure under an optional protocol to CEDAW, but again, only with regard to those parties to CEDAW that have additionally ratified the optional protocol. Anyone feeling a victim of a violation of CEDAW can, after exhaustion of domestic remedies, file an individual communication against the particular state party to CEDAW, and CEDAW can give views finding a violation and make recommendations, but they are not legally binding. They are just like the views by the Human Rights Committee under the Covenant. There's also an inquiry procedure. I won't go into that for reasons of time. I find important a resolution of the Human Rights Council of the United Nations, that is this subsidiary body of the General Assembly, the Human Rights Council. The Human Rights Council adopted a resolution in July 2019. It was adopted without a vote. In other words, it's based on an informal consensus, specifically on the elimination of all forms of discrimination against women and girls. It recognizes that discrimination against women and girls is inherently linked to deep-rooted patriarchal and gendered stereotypes and unequal power relations. That discriminatory attitudes, behaviors, norms, perceptions, customs, and harmful practices, such as female genital mutilation and child, early, and forced marriage, have direct negative implications for the status and treatment of women and girls. That gender-based environments promote impunity and impede the implementation of legislative and normative frameworks that guarantee gender equality and prohibit discrimination against women and girls. The Council also reaffirmed that the full enjoyment of all human rights by all women and girls includes their right to have control over and decide freely and responsibly on matters relating to their sexuality, including sexual and reproductive health, free from coercion, discrimination, and violence. It urges states to ensure women's and girls' equal enjoyment of economic, social, cultural, civil, and political rights through the prohibition of and appropriate action to eliminate all forms of discrimination by all actors, state and non-state alike. To remove barriers, whether political, legal, practical, structural, cultural, economic, institutional, or resulting from the misuse of religion, preventing the full, equal, effective, and meaningful participation of women and girls in all fields, including participation of women in leadership at all levels of decision-making in public and private sectors, and to actively promote diversity in leadership and an inclusive, enabling leadership culture. To modify social and cultural patterns of conduct with a view to preventing and eliminating in the public and private spheres, important also the private spheres, including in digital contexts, patriarchal and gender stereotypes, negative social norms, attitudes and behaviors, and unequal power relations that view women and girls as subordinate to men and boys, that underlie and perpetuate discrimination and violence against women and girls. To support substantive gender equality and women's and girls' rights, including within families, through long-term awareness-raising initiatives, including for men and boys, especially education and public awareness-raising, including in the media and online, and by ensuring universal access to evidence-based comprehensive sexuality education. And it also urges states to promote and protect sexual and reproductive health and reproductive rights, and to respect, protect, and fulfill the right of every woman to have full control over and decide freely and responsibly on all matters relating to her sexuality and sexual and reproductive health, free from discrimination, coercion, and violence, including through the removal of legal barriers and the development and enforcement of policies, good practices, and legal frameworks that respect bodily autonomy and guarantee universal access to sexual and reproductive health, services, and evidence-based information and education, including for family planning, safe and effective methods of modern contraception, and also safe abortion where not against national law. So the Human Rights Council didn't go as far as to urge states to allow, to permit abortion, but only to ensure access to abortion where not against national law. But in any event, it goes very far. In 2019, 40 years after the adoption of CEDAW, and all that urgings of states are important because they show that CEDAW has not been fully implemented, not at all in many parts of the world. Any questions on your side? Then I suggest to continue with the European level, and we start with the Council of Europe. The Statute of the Council of Europe of 1949 nowhere specifically refers to equal rights of men and women, in difference to the UN Charter. And there is no general agreement in the Council of Europe specifically protecting human rights of women, anything along the lines of CEDAW or the protocol to the African Charter and Human and People's Rights on the rights of women in Africa. But we do have, of course, the general treaty, the European Convention on Human Rights and Protocols, as well as the European Social Charter, that also protect the rights of women and in particular prohibit discrimination of women. And there are also several gender relevant Council of Europe agreements and gender-specific provisions in other Council of Europe agreements. With regard to the European Convention on Human Rights and Protocols, the Convention does not enshrine any gender-specific rights. It mentions women besides men only in Article 12 on the right to marry, but does not mention equality in this context, does not go as far as Article 23 of the International Covenant or the Universal Declaration on Human Rights. The general anti-discrimination provision in Article 14 guarantees the enjoyment of convention rights and freedoms without discrimination on suspect grounds and includes sex in its non-exhaustive list. Article 5 of Protocol 7 guarantees equal rights of spouses. Article 1 of Protocol number 12 extends the general prohibition of discrimination in Article 14 of the Convention to any rights set forth by law and prohibits discrimination by any public authority, leaving the list of suspect grounds in Article 14 unchanged and thus including, of course, sex. And the preamble of Protocol number 12 reaffirms the permissibility of affirmative action in favor of women. We do have some case law of the European Court of Human Rights with regard to the rights of women. One case in point is Konstantin Markin against Russia, that of 2012, that concerned the refusal of parental leave to fathers. Only mothers could ask for parental leave. Fathers could only ask for parental leave if they were not married and there was no woman that could take care of the child. And the court found that this violated Article 14 in conjunction with Article 8 of the Convention. It said that the court further reiterates that the advancement of gender equality is today a major goal in the member states of the Council of Europe, and very weighty reasons would have to be put forward before such a difference of treatment on the basis of sex could be regarded as compatible with the Convention. In particular, references to traditions, general assumptions or prevailing social attitudes in a particular country are insufficient justification for a difference in treatment on grounds of sex. For example, states are prevented from imposing traditions that derive from the man's primordial role and the woman's secondary role in the family. No way. Any questions from your side? Another case that's quite interesting is rather recent, was decided in February 2021, Giegerich v. Croatia, concerning the denial of employment health insurance coverage to pregnant women, was found to violate Article 14 of the Convention in conjunction with Article 1 of Protocol number 1 on the right to property. The court observes that only women can be treated differently on grounds of pregnancy, and for this reason, such a difference in treatment will amount to direct discrimination on grounds of sex if it is not justified. In the present case, the applicant was refused the status of an insured employee, and in that context, an employment-related benefit, namely the compensation of salary during sick leave, on grounds of employment which had been declared fictitious due to her pregnancy. The court notes that such a decision could only be adopted in respect of women, since only women could become pregnant. It therefore finds that in the applicant's case, such a decision constituted a difference in treatment on grounds of sex. The government argued that the decision to revoke the applicant's insurance status had pursued the legitimate aim of protecting public resources from fraudulent use and the overall stability of the healthcare system. In other words, the government argued it would have been too expensive to pay for that woman. The court said that at the outset, that a woman's pregnancy as such cannot be considered fraudulent behavior. Moreover, the court considers that the financial obligations imposed on the state during a woman's pregnancy by themselves cannot constitute sufficiently weighty reasons to justify difference in treatment on the basis of sex. The court cannot but express concern about the overtones of the domestic authorities' conclusion, which implied that women should not work or seek employment during pregnancy or mere possibility thereof. In the court's view, gender stereotyping of this sort presents a serious obstacle to the achievement of real, substantive gender equality, which, as already stated, is one of the major goals in the member states of the Council of Europe. Very recent case. Any questions? Let's turn to other Council of Europe conventions concerning women's rights. As I said, there is no parallel to CEDAW in the Council of Europe, but we do have conventions which do include women's rights. There is Article 14 of the Convention on Human Rights and Biomedicine that prohibits the use of techniques of medically assisted procreation for the purpose of choosing a future child's sex. So no distinction in this regard, except where a serious hereditary sex-related disease is to be avoided. The Council of Europe Convention on Action Against Trafficking in Human Beings, though gender neutral, is primarily protecting women because they are the primary victims of trafficking in human beings. And then, of course, we have the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, the Istanbul Convention, which also primarily protects women. I will turn my attention to that Istanbul Convention. The motivation, according to the preamble, is this: the realization of de jure and de facto equality between women and men is a key element in the prevention of violence against women. Recognizing that violence against women is a manifestation of historically unequal power relations between women and men, which have led to domination over and discrimination against women by men, and to the prevention of the full advancement of women. So it's also recognized that there's a structural nature of violence against women as gender-based violence, and that violence against women is one of the crucial social mechanisms by which women are forced into a subordinate position compared with men. Women and girls are often exposed to serious forms of violence, such as domestic violence, sexual harassment, rape, forced marriage, crimes committed in the name of so-called honor, and genital mutilation, which constitute a serious violation of the human rights of women and girls and a major obstacle to the achievement of equality between women and men. What are the purposes of the Istanbul Convention? Under Article 1, Paragraph 1, the purposes of the Convention are: A, to protect women against all forms of violence and prevent, prosecute, and eliminate violence against women and domestic violence. To contribute to the elimination of all forms of discrimination against women and promote substantive equality between women and men, including by empowering women. To design a comprehensive framework, policies and measures for the protection of and assistance to all victims of violence against women and domestic violence. to promote international cooperation with a view to eliminating violence against women and domestic violence, and to provide support and assistance to organizations and law enforcement agencies to effectively cooperate in order to adopt an integrated approach to eliminating violence against women and domestic violence. The Council of Europe Conventions usually have an explanatory report that gives the major motives and reasons why that convention was drafted and how it was drafted. And in the explanatory report to the Istanbul Convention, you find this: that violence against women, including domestic violence, is one of the most serious forms of gender-based violations of human rights in Europe, and that is still shrouded in silence. Surveys suggest that across countries, 1/5 to 1/4 of all women have experienced physical violence at least once during their adult lives, and more than 1/10 have suffered sexual violence involving the use of force. Figures for all forms of violence, including stalking, are as high as 45%. The majority of such violent acts are carried out by men in their immediate social environment, most often by partners and ex-partners. Domestic violence against children is widespread, and for other forms of domestic violence, such as elderly abuse and domestic violence against men, reliable data is relatively scarce, but we do have data with regard to women. As a regional instrument open for ratification and accession to non-member states, the Convention complements and expands the standards set by other regional human rights organizations. In this field, they mention the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women of the OAS of 1994, and the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa that was adopted in 2003 by the African Union. Both address the issue of violence against women, but the Council of Europe Convention, the Istanbul Convention, is more comprehensive in nature and thus significantly reinforces action to prevent and combat violence against women and domestic violence at world level. The scope of the Istanbul Convention is set forth in Article 2. It shall apply to all forms of violence against women, including domestic violence, which affects women disproportionately. And states parties are encouraged to apply this convention to all victims of domestic violence, but that they shall pay particular attention to women victims of gender-based violence in implementing the provisions of this convention. And interestingly, this convention shall apply in times of peace and in situations of armed conflict, and no derogations allowed for armed conflict. Article 3 gives some important definitions for the purposes, of course, of the Istanbul Convention. Violence against women is understood as a violation of human rights and a form of discrimination against women, and shall mean all acts of gender-based violence that result in or are likely to result in physical, sexual, psychological, or economic harm or suffering to women, including threats of such acts, coercion or arbitrary deprivation of liberty, whether occurring in public or in private life. Domestic violence shall mean all acts of physical, sexual, psychological, economic violence that occur within the family or domestic unit or between former or current spouses or partners, whether or not the perpetrator shares or has shared the same residence with the victim. Gender shall mean the socially constructed roles, behaviors, activities, and attributes that a given society considers appropriate for women and men. And gender-based violence against women shall mean violence that is directed against a woman because she is a woman, or that affects women disproportionately. The general state obligations are set forth in Article 4. Parties shall take the necessary legislative and other measures to promote and protect the right for everyone, particularly women, to live free from violence in both the public and the private sphere. The parties condemn all forms of discrimination against women and take, without delay, the necessary legislative and other measures to prevent it. States shall refrain from engaging in any act of violence against women and ensure that state authorities and so on act in conformity with this obligation. But they also take all necessary legislative and other measures to exercise due diligence to prevent, investigate, punish, and provide reparation for acts of violence covered by the scope of this convention that are perpetrated by non-state actors. And Article 6 concerns gender-sensitive policies. Parties shall undertake to include a gender perspective in the implementation and evaluation of the impact of the provisions of the Convention, and to promote and effectively implement policies of equality between women and men and the empowerment of women. With regard to the implementation of the Convention, a treaty body is set up that is called GREVIO, that is the Group of Experts on Action Against Violence Against Women and Domestic Violence. They are responsible for the consideration of regular state reports. GREVIO reacts to those reports by adopting its own reports with conclusions that are made public. Based on GREVIO reports, the Committee of the Parties can make recommendations to a particular party. GREVIO can conduct inquiry into serious, massive, or persistent pattern of violence against women. Based on the inquiry, GREVIO can send recommendations to the Committee of the Parties and the Committee of Ministers of the Council of Europe. There are no interstate applications or individual applications under the Istanbul Convention, but they are possible pursuant to Article 33 and Article 34 of the European Convention on Human Rights, because often, perhaps not always, but often, a state that violates obligations under the Istanbul Convention will at the same time also violate obligations under the European Convention on Human Rights. For instance, the duty to protect people from violence by others under Article 3, for instance, of the European Convention, or if it's deadly violence under Article 2 of the European Convention on Human Rights. And these obligations can, of course, be implemented in the normal form by application to the European Court of Human Rights. And so indirectly, at least some of the obligations under the Istanbul Convention can be implemented by the Strasbourg Court. Now, that is what I wanted to tell you about the Council of Europe. I will still have some minutes for EU law, but if you have questions on the Council of Europe, please ask them. Yes, please.
Yes, I wanted to, well, I guess not really that much of a question. I'm just curious on your stance, because Turkey has withdrawn from the Istanbul Convention. And
because the situation of women in Turkey is perfect.
And as well as the pandemic, which gave rise to gender violence in a sense. The IEG even has like a special meter for violence now in their index reports. So,
well,
yeah.
it's a very, very sad that Turkey withdrew from the Istanbul Convention. They were proud to be the first to ratify it originally, and it's called Istanbul Convention because it was adopted by the Committee of Ministers in a session in Istanbul in 2011. It's very sad. The unfortunate thing is that there are other states considering withdrawal, and one is Poland. They haven't done so, but you know, if you have a conservative government that's closely affiliated to religious organizations, they will sometimes feel bothered by obligations under the Istanbul Convention because they're not always in line with religious conceptions of the role of women. And that's the trouble. I hope that sooner or later Turkey will return to the Istanbul Convention, but that will certainly take time. And in the meantime, we will have to put up with Turkey's obligations under the European Convention on Human Rights.
They're also party to CEDAW as well, I think.
To what? CEDAW, yes, of course.
Yeah,
of course. On the world level, and of course, violence against women and not doing enough against violence against women also violates CEDAW. And but it's a symbolic step, a very unfortunate symbolic step. Concerning the pandemic, the president of the European Commission, von der Leyen, in her State of the Union address, mentioned the increase in the number of violent actions against women during the pandemic and promised that she would propose a legal act, a secondary act, probably a directive under European Union law to combat violence against women. But that is just a promise made. There is no proposal by the Commission yet. And that wouldn't cover Turkey, of course. But perhaps we go just through the EU law very briefly. Primary law, of course, the fundamental values of the European Union under Article 2 of the Treaty on European Union includes equality between women and men. We do have further provisions in the Treaty on European Union and the Treaty on the Functioning of the European Union, which imposes the obligation on the Union in all its activities to promote equality between women and men and to combat discrimination based on sex. We do have a specific provision permitting legal acts to combat discrimination based on sex. And on that provision, the future proposal by the Commission will have to be based, that's Article 19, paragraph 1, TFEU. Now, if you just read that provision, do you think it's easy to enact a directive combating violence against women?
I think we shall see. It depends.
Well, is it easy?
No, for instance.
Easy? Why not?
Well, I think maybe it will pass because it's a generally agreed upon thing. Maybe because, for instance,
what do you need to enact any directive to combat discrimination based on sex and in particular violence against women? What do you need?
Well, you need the countries to agree, basically.
Yes, unanimously. The council must act unanimously. You need a unanimous.
So it would be a sort of political battle in a sense.
Yes, and if Poland or Hungary drag their feet, it will be difficult. Let's see. Yeah? So in other words, the treaty doesn't make it easy to fulfill the promise of equality of men and women, to let it be implemented by positive action. That's made very difficult because of the unanimity requirement. And then we have Article 157 TFEU. That was a provision that already existed in the original EEC Treaty of 1957, equal pay for male and female workers. And still, in reality, we haven't yet arrived at that goal. It's not yet fully implemented still. We also have, of course, provisions in the Charter of Fundamental Rights. It's discrimination based on sex, of course, and to ensure equality between women and men in Article 23. And again, the right to equal pay for equal work, and so on and so forth, and the permissibility of positive action in favor of the underrepresented sex, which is usually women. We do have a lot of secondary law concerning women's rights and a number of council directives. They are based on either Article 19 or the predecessor provision. They were all passed unanimously by the council. So we do have some directives supporting the rights of women, even though they had to be passed unanimously. That's the Goods and Services Directive. Then the Equal Treatment Directive of 2006, that was recast, the original directive dated of 1976. And we have another directive on equal treatment between men and women engaged in an activity in a self-employed capacity. To take the Equal Treatment Directive as an example, that gives the definitions of direct and indirect discrimination. I won't go into that in any detail because of time reasons. It also explains that harassment and sexual harassment is prohibited. Both kinds of harassment are considered as discrimination in the sense of the Equal Treatment Directive. Harassment and sexual harassment, as I said, are discrimination for the purposes of the directive. Positive action. Member states may maintain or adopt measures with a view to ensuring full equality in practice between men and women in working life, that is affirmative action, specific treatment of women to promote their de facto practical equality. And then there is a provision on compensation and reparation, and so on and so forth. I cannot go into that. I just want to mention some important cases of the Court of Justice of the European Union. The court decided already in 1976 that the prohibition of unequal pay for men and women for equal work has direct effect, so that you can directly invoke it in national courts, and that it also binds private employers. You can sue an employer as a woman for additional pay if you are discriminated in this regard, based on Article 157, paragraph 1 TFEU. It was also decided that the prohibition of discrimination in Article 21 of the Charter of Fundamental Rights binds private employers. The court decided that the discrimination of part-time workers amounts to indirect discrimination of women if part-time work is predominantly done by women, as it usually is. And also, the discrimination of domestic workers amounts to indirect discrimination of women if domestic workers are almost exclusively women. That is not yet decided by the court, but the Advocate General issued an opinion in this regard a couple of days ago. Concerning affirmative action, the Court of Justice is a bit tricky. It's said that national rules which give women absolute and unconditional priority for appointment or promotion are incompatible with the Equal Treatment Directive. So no absolute priority, an unconditional priority. There must be some possibility to consider the particular case of the male competitor. Now, the way ahead, I already mentioned the State of the Union address of the 15th of September of this year, where President von der Leyen spoke about abuses of women, including in the pandemic, freedom from fear, violence against women, and that we must do something about it. Women must have their freedom and their self-determination back. This is why by the end of year, we will propose a law to combat violence against women, from prevention to protection and effective prosecution, online and offline. So let's wait and see. It is about defending the dignity of each individual. It's about justice, because this is the soul of Europe and we must make it even stronger. How true? One last issue, and then I let you go into your break. The ratification of the Istanbul Convention by the EU. The EU can accede to the Istanbul Convention. It's open to accession by the EU. The EU signed it in June 2017. Of the 27 member states, 21 have ratified it, but 6 have not yet done so. The EU ratification process is suspended because of an opinion procedure, the opinion procedure 1/19 under Article 218, paragraph 1 TFEU, that actually it was pending before the Court of Justice, because today, this morning, the Court of Justice issued the opinion, 6 October 2021, where it said that the treaties do not prohibit the Council from waiting before adopting the decision concluding the Istanbul Convention on behalf of the EU for the common accord of the member states, but the Council cannot alter the procedure for concluding that convention by making that conclusion contingent on the prior establishment of such a common accord. In other words, the Council cannot say, we must have proof that all member states have ratified the convention before we take our decision. But they can, of course, continue discussing on whether the EU should ratify or not, and continue and continue and continue informally until the date in which all member states have ratified. But under the rules of procedure of the Council, a vote of the Council can always be forced by the Commission or by a member of the Council. And if then the majority of the member states agree, and a qualified majority agrees to ratifying the Istanbul Convention, then it will be ratified. So it's just an informal process of political discretion on whether to postpone the Council's vote, but nothing which could be made contingent on prior ratification by the member states. That's from the press release. The opinion wasn't available in English this morning, yet it may be available by now. Now, this is all I wanted to tell you. It was quite a lot of stuff, I think. Do you have any questions you want to pose?
Hi, can I ask one question, please?
Yes, of course.
Could you briefly elaborate on the issue of the US not being a member of CEDAW? Because it's really, as far as I know, I think they signed the convention back in the 80s or something.
Yes.
But to this day, the convention, as you said, the convention remains unratified.
Yes. The trouble is that you need a 2/3 majority in the Senate for ratifying a treaty, and that is hard to come by. You may remember, I don't know whether we remember, you were not alive yet, but in the 70s, in the Carter administration, they tried to amend the US Constitution by an equal rights amendment, which would have written equal rights for women into the US Constitution. And that was unsuccessful. They didn't find the necessary ratifications of 3/4 of the states, the constituent states of the United States. So we still do not have the provision on equal rights specifically for women written into the US Constitution. Why is this? Let me guess, it may be because the Americans are a religious people. They are so religious, and so many of them are so religious, especially in some of the states, that they do not think equal rights for women need to be written into the Constitution or need to be ratified in CEDAW. But that's my guess. I can't prove it. But as a matter of fact, we do not have a 2/3 majority for ratification of CEDAW, and I do not see that coming anytime soon. Yeah. I wonder whether they will first ratify CEDAW or first abolish the death penalty. But that's sarcastic. Sorry, sometimes you need to be sarcastic. No?
Yeah.
So no light at the end of the tunnel, to my mind.
So it all
They
comes back to
ratified
the
the covenant, the International Covenant on Civil and Political Rights, and so they are subject to some kind of control, including concerning women's rights. You know, the major issue in the United States in this regard is abortion, of course. And you know, Roe v. Wade, and you know that Roe v. Wade is currently challenged, and that the Supreme Court has been asked to overturn it, to overrule it. We'll see whether they do it. Yeah, it will be a close call. It will be a very close call. So let's wait and see.
Okay, thank you very much.
Sorry for disappointing you. Okay, any further question? Well, if you have one, you send me an email. You can just go into your break and think about questions later and send me an email.